I've been asked to set the scene, and I'm going to do it partly in my capacity as a member of the advisory committee of the Sri Lanka Campaign for Peace and Justice. We've put out a preliminary short version of some of what I'm going to say. It's called The Breakdown of the Rule of Law in Sri Lanka, an overview. And what I'm working on right now is a final version that may well end up being submitted to a panel that's been created by the UN Secretary General with respect to alleged war crimes and crimes against humanity occurring in the last few months of the war last year. Allow me to also acknowledge the primary author of much of this document, although not all of what I'm about to go through, is James Yap, who's a recent graduate of Osgoode Hall Law School. Allow me to begin with two quotations, and I'm going to kind of ventriloquate in this talk. I'm going to be using a fair number of quotations because I want you to, in some sense, benefit from the authority of a number of speakers and not just take it from me. Let me begin with the following. When liberties are taken away and when domestic institutions, democratic institutions die, is it even worse than human beings dying? This is a query that came to my mind when writing to a colleague and a friend this Wednesday. His immediate answer, that when institutions die, living people end up living as if they were dead, touched a raw nerve. This is by Kishali Pinto Jawadina, who's a very brave and acutely insightful lawyer and researcher in Sri Lanka, who wrote that a few days ago, September 12th, in a column in the Sri Lankan newspaper. Second quotation, there's been a deafening global silence in response to Sri Lanka's actions, especially from its most influential friends. The international community cannot be selective in its approach to upholding the rule of law and respect for human rights. Impunity anywhere is a threat to international peace and security everywhere. Kofi Annan, former Secretary General of the UN and member of the Elders. And the Elders is an independent group of global leaders brought together by Nelson Mandela in 2007. And they offer their collective influence and experience to support peace building, help address major causes of human suffering, and promote the shared interests of humanity. And they spoke out on August 3rd of this year on the Sri Lankan situation, with the former president of Finland and a well-known peacemaker by way of being a mediator, Martti Ahtisaari, commenting at the time of the release, quote, countries operating outside international norms watch each other carefully. They will be taking courage from Sri Lanka's apparent success at avoiding international reproach. This is a worry for all those who want to see more democracy, greater respect for human rights, and less violence in the world. So the overview that is this document, that I'm obviously not going to be able to get through in a 15-minute scene setting, analyzes the state and the underlying causes of the current breakdown of the rule of law in Sri Lanka. And much of it is organized around years, decades of research, and recent publications of Basil Fernando, who's a member of the Asian Human Rights Commission based out of Hong Kong, and also a co-member of the Advisory Council for the Sri Lanka Campaign for Peace and Justice. And in his very recent 2010 book, Sri Lanka, Impunity, Criminal Justice, and Human Rights, he describes the current situation in Sri Lanka as one of, quote-unquote, abysmal lawlessness. Now, lawlessness of this sort differs from simple illegality or disregard for law, which to differing degrees happen everywhere. Lawlessness is abysmal when law ceases to be any reference at all. Of special relevance to the theme of the breakdown of the rule of law in Sri Lanka is that under circumstances of abysmal lawlessness, the concept of legal redress, which is vital to the proper functioning of any legal system, has in fact been completely decoupled from whatever may be called law. In Sri Lanka, the primary cause of this decoupling has been the fundamental failure of the public institutions responsible for the implementation of legal redress. Now, Sri Lanka's justice and accountability institutions have been eroded to the point that they've become not simply dysfunctional, but also sham institutions. Institutions that are little more than hollow impressions that merely approximate some of the external characteristics of genuine, functional institutions. Now, Sri Lanka does not lack for a constitution, a court system, and other formal mechanisms for legal redress, and it is an electoral democracy. However, none of the institutions carry much more depth or substance to them than a Hollywood film set. In other writing, Fernando has evoked the medical metaphor of the phantom limb to evocatively convey this chasm between appearance and reality with respect to the institutions of Sri Lanka's legal system. And let me now give full credit to Basil with this following quotation. It comes from a blog of June 28th of this year. Quote, a medical doctor who attended a presentation I made on the absence of institutions for administrations of justice and its impact on human rights suggested the term phantom limb. In response to my speech, he said that the situation I described in Sri Lanka was known as the phantom limb syndrome. An amputee who has lost a limb continues to imagine that he has that limb and even feels pain in the limb. The problem of institutions for administration of justice is similar. Because certain institutions were formed at certain times in history, particularly colonial times, this has given rise to the feeling that these institutions still exist and function more or less as before. In this way, they become phantom limbs. Now, the numerous commissions of inquiry that have been appointed over the past couple of decades to address human rights concerns in Sri Lanka illustrate this phenomenon quite well. And paralleling Fernando's phantom limb theme, Amnesty International recently, in one of its longer reports on Sri Lanka, refers to this period of the last couple of decades in specific reference to commissions of inquiry as, quote unquote, 20 years of make-believe. Now, this will be the primary focus of what I'm likely to get through in the next 7 to 8 minutes. And I've chosen this in view of the fact that Sri Lanka has again appointed a commission of inquiry, while against furious protests from Sri Lanka, UN Secretary General Ban Ki-moon has appointed a panel of 3 experts to report to him and to be available to assist the Sri Lankan Commission of Inquiry should Sri Lanka wish. It's, as a context, a very important feature of the evolving accountability discourse and pressure discourse around Sri Lanka, and therefore that will be my focus. Now, outwardly, commissions of inquiry are designed to resemble other similar institutions around the world that undertake credible investigations and produce meaningful findings. However, as incarnated in Sri Lanka, they currently serve and have served little more purpose than to either relieve domestic pressure or to discredit the previous government. Not as if we haven't seen that function in some of our own commissions of inquiry. But nonetheless, governments frequently are so brazen as to tailor a particular commission's mandate to specifically restrict its investigations to a time period coinciding with a particular predecessor regime. Evidence is also frequently manipulated. Recommendations are usually ignored, and preliminary findings of responsibility are rarely followed through with judicial proceedings. Reports are frequently released to the public only after long delays, or in certain cases, not at all. Also, institutional limitations abound. For example, there are no built-in safeguards to protect the safety of victims and witnesses. Also, commissioners can be removed at the unreviewable discretion of the president and therefore lack independence. Now, in 2006, it's only 4 years ago, a commission of inquiry to investigate and inquire into alleged serious violations of human rights, that's the official title, all those are capital letters, was established. In response to concerns over the problems associated with past commissions, the President invited a panel of 11 international experts to supervise the Commission's process and ensure its integrity. By November 2007, so the next year, the experts had had enough. Citing persistent interference by the Attorney General, as well as a lack of transparency, a lack of timeliness in proceedings, a lack of victim and witness protection, a lack of financial independence, and a lack of cooperation from state bodies, they tendered their resignations en masse. Noting further that the recommendations contained in their interim reports, that is, from the 11 international experts, had largely gone ignored, they concluded there was, quote, an absence of political and institutional will on the part of the government to pursue with vigor the cases under review, unquote. Definitively putting to rest any lingering doubts as to the true nature of Sri Lankan commissions of inquiry. The Attorney General's response to the international experts' criticism was to release a statement accusing the international experts of being involved in an international sinister plot. And those of you who follow much of the discourse around Sri Lanka, this is not an uncommon form of language and an uncommon kind of accusation coming from the Sri Lankan government.